In an unprecedented showdown, White House Press Secretary Karoline Leavitt found herself facing the full might of the U.S. Supreme Court, accused of contempt over her outspoken criticism of a recent ruling. What unfolded next was nothing short of extraordinary. A young press secretary, armed with nothing but her legal acumen and a 15-page defense, taking on one of the most powerful courts in the world. This wasn't just a battle for her career. It was a defining moment for the very principles of free speech and judicial authority. But before we dive into this story, I want to hear from you. Comment down below, where in the world are you watching from? Let's light up this comment section. And hey, if you love stories with high drama, power shifts, and the kind of moments that leave people speechless, you're in the right place. Tap that subscribe button right now. Hit the notification bell so you never miss when we drop the next chapter in these powerful, untold stories. In this remarkable tale, Leavitt turns the tables on Supreme Court Justice Amy Coney Barrett, defending her right to criticize judicial decisions using the court's own precedents. What begins as an attempt to silence her transforms into a profound constitutional debate that reshapes the relationship between the executive and judicial branches of government. Join us as we break down this historic confrontation and discover how a press secretary became an unlikely constitutional genius, forcing the highest court to reconsider the boundaries of free speech. The Supreme Court chamber was thick with anticipation as the gavel of Justice Amy Coney Barrett echoed sharply through the room, bringing the proceedings to a sudden hush. The atmosphere was tense, charged with an air of expectation, as all eyes turned to the bench. Justice Barrett, known for her unyielding stance and sharp legal mind, spoke in a voice that sliced through the silence like a blade of steel. "Miss Leavitt," she began, her gaze steady and unwavering, "this court finds your repeated statements about our recent decision deeply concerning. You stand perilously close to contempt." The words hung in the air, heavy with the weight of their potential consequences. For anyone else, facing a contempt charge from the highest court in the land might feel like a career-ending moment. Yet Leavitt stood unshaken, her composure resolute. Karoline Leavitt, at just 28 years old, was the youngest person ever to be summoned before the Supreme Court for such a charge. As the White House press secretary, she had quickly become a familiar figure in Washington, known for her boldness and forthright communication style. But today, she wasn't facing the press or responding to questions in the White House briefing room. Today, she was standing before the very institution that upheld the law of the land, accused of threatening its authority. Barrett's voice continued, calm yet tinged with severity. "You have 7 days to retract your statements and issue a formal apology, or this court will have no choice but to refer this matter for criminal prosecution." The words were precise and damning. The gallery of onlookers, consisting of legal experts, journalists, and court staff, gasped in collective disbelief. The reporters who had gathered expecting a routine session frantically typed away on their phones, eager to capture every moment of this unprecedented confrontation. But instead of cowering in fear or rushing to apologize, Leavitt remained unfazed. She moved slowly and methodically, opening a sleek leather portfolio she had brought with her. As she did, it was clear she was not about to offer the expected mea culpa. Instead, her calm, measured response cut through the courtroom tension. "Justice Barrett," Leavitt said, her voice clear and unyielding, "I've prepared a 15-page legal analysis explaining why my statements are not only protected, but legally correct." The sheer audacity of her move stunned the room into silence. Here was a young press secretary, who had faced what could be a career-ending accusation, ready to take on the highest court in the land, not with a simple apology, but with a legal defense that could potentially reshape the boundaries between free speech and judicial authority. What happened next would stun the court, the media, and the nation. In what would become a historic moment, Leavitt would go toe-to-toe with the justices, wielding constitutional arguments with such skill and precision that even the most seasoned legal minds in the room would be forced to reconsider their positions. This wasn't just a legal battle for Leavitt. It was a battle for the very principles that uphold the American system of justice. Before the unexpected legal showdown could unfold, the backdrop of this confrontation needed to be set. Justice Amy Coney Barrett, appointed to the Supreme Court in 2020, had quickly established herself as one of the court's most influential figures. Known for her unyielding conservative stance, Barrett had risen through the ranks of the legal community with a reputation for precise legal reasoning and a no-nonsense approach. A former law professor at Notre Dame and a seasoned constitutional scholar, she had become a force to be reckoned with in the court, especially as a staunch defender of judicial authority. At 52, Barrett was already a commanding presence, respected by allies and adversaries alike. Her intellectual rigor and steadfast demeanor made her a formidable voice in the courtroom, particularly when it came to navigating the constitutional intricacies of cases that threatened the institutional integrity of the court itself. However, as much as she had become synonymous with a conservative judicial philosophy, Barrett was also sensitive to public criticism. She had always maintained that such critiques, especially when deemed uninformed or misleading, were dangerous not only to the integrity of the court, but also to the very principles that upheld American democracy. The one thing that Barrett could not abide was what she saw as attempts to undermine the court's authority, especially when coming from those who should be upholding the law. Karoline Leavitt, by contrast, represented a fresh and formidable voice in the political landscape. At just 28 years old, she had been appointed White House press secretary only 6 months earlier. But her impact on the political scene was already undeniable. Known for her sharp, direct communication style and unwavering defense of the administration's positions, Leavitt had become an effective spokesperson, often holding her ground in the face of intense scrutiny. But few knew the full depth of her background. Before stepping into the spotlight of national politics, Leavitt had quietly pursued law studies, completing a double major in politics and communications at St. Anselm College before quietly earning a law degree through evening classes. While her legal credentials were kept low-key, they were undeniably impressive. Leavitt had balanced her demanding political career while earning her law degree, maintaining a remarkable 3.9 GPA. It wasn't until this moment, in front of the highest court in the land, that the full extent of her legal training would come to light. Few outside of her close circle were aware of the depth of her constitutional knowledge. Now, however, she was about to put it to the test in a way no one expected. The seeds of this unprecedented confrontation had been sown 3 weeks earlier when the Supreme Court issued a controversial 5-4 ruling in Fairfield v. Department of Education. The case limited the scope of federal oversight in state education policies, a ruling that sent shockwaves through Washington, particularly at the White House. Leavitt, who had become known for her frankness, didn't hold back during a press briefing following the decision. She had called out the court's ruling, not with rhetoric, but with a forceful critique. This ruling represents a fundamental misreading of precedent and legislative intent. The majority opinion ignores 70 years of established jurisprudence and substitutes judicial preference for constitutional principle. The comments were far stronger than the usual responses from White House officials to Supreme Court decisions, and they immediately drew a sharp response from both conservative and liberal legal commentators. Some saw her words as a necessary challenge to the court's power, while others felt that Leavitt's critique crossed a line, perhaps even into contempt. Conservative voices, particularly those in the media, quickly labeled her statements as not just critical, but as an affront to the court's integrity. Calls for disciplinary action were swift, with some suggesting that Leavitt should face consequences for what they deemed an inappropriate and dangerous undermining of the judicial system. On the other hand, progressive supporters rallied behind her, arguing that she had every right to voice her concerns about what they viewed as an overreach by the court. The question of whether Leavitt's remarks had indeed crossed the line into contempt became the focal point of a nationwide debate. The legal community was divided, and public opinion was sharply polarized. At stake wasn't just the career of a rising political star, it was the question of whether a government official, in her role as press secretary, could publicly criticize the highest court in the land without facing legal repercussions. Could a White House official criticize a Supreme Court decision without risking criminal charges for contempt? For Leavitt, this controversy wasn't just about defending her career. It was about standing up for the very values enshrined in the U.S. Constitution. What began as a routine day of political commentary had escalated into a potential constitutional crisis, one that forced the nation to reckon with the balance between judicial authority and the fundamental right to free speech. Now, with Leavitt summoned to the Supreme Court to answer for her comments, the moment of reckoning had arrived. All eyes were on the court, and the stakes couldn't have been higher. What happened next would not only determine Leavitt's fate, but would force a broader reevaluation of the relationship between the branches of government and the freedoms guaranteed by the Constitution. Would she buckle under pressure, as many expected, or would she stand her ground and confront the court with a legal defense that could shake the very foundations of judicial authority? The stage was set for a historic battle. The tension in the Supreme Court chamber reached a boiling point as Leavitt prepared to make her case. It all started 3 weeks earlier when the Supreme Court delivered a controversial 5-4 ruling in Fairfield v. Department of Education, a case that limited the scope of federal oversight over state education policies. The decision was seen by many as a significant blow to federal authority, especially in areas where the government had traditionally played an active role in shaping educational outcomes. The ruling sent ripples through Washington, sparking fierce debates on both sides of the political spectrum. For the White House, the ruling was more than just a policy concern. It was a direct challenge to their vision for the country. Leavitt, in her role as the press secretary, had long been the face of the administration's communications efforts, known for her no-nonsense approach and her willingness to stand her ground in the face of fierce opposition. And she wasn't about to let the court's ruling pass without comment. During a press briefing following the decision, Leavitt made an impassioned statement that would ultimately land her in the Supreme Court chamber. This ruling represents a fundamental misreading of precedent and legislative intent, she declared, her voice unwavering. The majority opinion ignores 70 years of established jurisprudence and substitutes judicial preference for constitutional principle. Her words struck like a hammer. These were not the typical, cautious responses that government officials often gave when commenting on Supreme Court rulings. Leavitt's critique was pointed and bold, challenging not only the court's decision, but the very foundation of its interpretation of the law. Her remarks were a direct challenge to the court's authority, questioning its understanding of constitutional principles and historical precedent. Leavitt's comments did not go unnoticed. Conservative legal commentators quickly seized on her words, accusing her of overstepping her bounds and undermining the integrity of the judiciary. Some even went so far as to call for her to be held accountable for contempt of court, a charge that could result in fines, imprisonment, or both. To these critics, Leavitt's statements were not simply critical. They were an attack on the authority of the highest court in the land, and such actions could not be tolerated. Meanwhile, progressive voices defended Leavitt, arguing that her comments were not only justified but necessary. They saw her statements as a brave stand against what they viewed as an increasingly activist court that was overreaching its constitutional boundaries. After all, they reasoned, the First Amendment guaranteed the right to criticize even the highest levels of government, including the judiciary. The controversy quickly escalated, sparking a national debate. Was Leavitt simply exercising her First Amendment rights to speak out against a decision she disagreed with? Or had she crossed a line that threatened the very balance of power between the executive and judicial branches of government? Legal scholars found themselves divided. Some believed that Leavitt had a right to voice her opinion, while others worried that her words could embolden others to challenge judicial authority in ways that might undermine the public's trust in the court. The real drama began when Leavitt received an official summons to appear before the Supreme Court to answer for her comments. For the White House, this was uncharted territory. Never before had a press secretary been called before the court to address accusations of contempt. In fact, Leavitt's case was unique in its very nature. There was no clear precedent for a White House official facing legal repercussions for criticizing the court. The implications of this case were enormous, and everyone from legal experts to political pundits speculated on what might come next. Leavitt, however, was not fazed by the enormity of the situation. While her legal team initially advised her to apologize and retract her statements to avoid further escalation, Leavitt was determined to take a different approach. For the past 3 sleepless nights, she had buried herself in research, combing through Supreme Court precedents on contempt charges, free speech limitations, and the delicate relationship between the executive and judicial branches of government. What she discovered in her research would become the foundation for her defense, a defense that would ultimately challenge the very notion that the court had the authority to stifle political speech from government officials, especially when that speech was aimed at judicial decisions. She unearthed a number of landmark cases, including Bridges v. California, 1941, New York Times v. Sullivan, 1964, and Texas v. Johnson, 1989, all of which reinforced the fundamental idea that public criticism of judicial decisions, even harsh criticism, was protected by the First Amendment unless it presented a clear and present danger to the administration of justice. In those cases, the court had consistently ruled that speech related to public matters, especially political speech, was essential to the health of a democracy. This was the line of reasoning Leavitt would use to defend her remarks. She argued that her criticism of the court's ruling in Fairfield was not an attack on the court's integrity, but a reasoned legal argument. She had not questioned the legitimacy of the court's authority. She had simply disagreed with its interpretation of the law, which, she argued, was well within her rights as a government official and as an American citizen. As Leavitt prepared to face the justices, the implications of her stance became ever clearer. If she succeeded, her defense would not only vindicate her right to criticize the court, it would also force a broader conversation about the limits of judicial authority and the protection of free speech in the context of government officials. This wasn't just about one press secretary defending her position. It was about ensuring that the executive branch could challenge the judicial branch's interpretations without fear of reprisal, setting an important precedent for future administrations. And so, as Leavitt entered the Supreme Court chamber that fateful day, she knew she wasn't just defending herself. She was engaging in a legal battle that would reverberate throughout the history of American democracy. The entire nation was watching, and whatever happened next would shape the future of the relationship between the branches of government and, ultimately, the constitutional rights of every American citizen. The stakes had never been higher. As Karoline Leavitt stood in the Supreme Court chamber, the weight of the moment was almost tangible. Every eye in the room was on her, every mind focused on what would happen next. The justices, who had heard countless arguments over the years, were now about to hear from a 28-year-old press secretary who had quickly become a national figure. But Leavitt wasn't here to offer an apology. She wasn't here to cower in the face of the court's authority. She was here to present a carefully constructed defense, one that she hoped would not just save her career, but reshape the boundaries of free speech and judicial power in America. Her legal team had been clear. Retract the statements, issue a public apology, and the matter would likely be put to rest. But Leavitt had other ideas. After days of intensive research, she knew that her comments, critical as they were well within the bounds of the First Amendment. She wasn't attacking the court's legitimacy. She was criticizing a legal decision that she believed misinterpreted decades of precedent. And after poring over past Supreme Court rulings, she was confident that the law was on her side. But the stakes were high. If the court ruled against her, Leavitt would not only face a contempt charge, but likely a career-ending consequence that would forever taint her reputation in Washington. The implications were far-reaching. If the court took action against her, it could send a chilling message to future government officials who wished to publicly criticize judicial decisions. The very notion of judicial authority in the modern age was at stake. Could the court silence political speech from elected officials and government representatives, or would the First Amendment prevail? The justices themselves were visibly interested. Chief Justice Roberts, who was often the more restrained figure in the courtroom, watched closely. Justice Kagan leaned in, curiosity piqued by Leavitt's confident demeanor. Even Justice Thomas, known for his occasional silence during proceedings, seemed to be paying attention. And at the center of it all was Justice Barrett, who had summoned Leavitt to appear, now looking on as the young press secretary prepared to take a bold stand for her right to speak out. In the preceding weeks, the nation had watched this controversy unfold with growing interest. Legal scholars had pored over Leavitt's comments, some arguing that they represented an unwarranted challenge to judicial authority, while others saw her as a brave defender of free speech. The media had been divided as well, some outlets calling for swift action, while others supported Leavitt's right to speak her mind. But now here, in the Supreme Court chamber, Leavitt had a chance to make her case directly to the 9 justices. She opened the leather portfolio with measured precision and without hesitation began to speak. Justice Barrett, I believe the court has erred in its interpretation of the law, and I intend to show why my statements fall squarely within the protection of the First Amendment. Leavitt began, her voice clear and composed. I will not apologize for voicing my concerns about a decision that I believe misinterprets decades of legal precedent. As she spoke, Leavitt referenced key Supreme Court cases that had established the broad protections of free speech, even when it involved criticism of judicial decisions. She cited Bridges v. California at 1941, which had held that criticism of judges and judicial decisions was protected speech unless it posed a direct and present danger to the administration of justice. She also pointed to New York Times v. Sullivan, 1964, in which the court had ruled that debate on public issues should be uninhibited, robust, and wide open, including sharp criticisms of public officials, even judges. Her argument was methodical, referencing case law with remarkable precision. She wasn't just making broad statements, she was backing up each of her points with clear legal reasoning, citing specific case law and pointing to the court's own precedents. In essence, Leavitt was using the court's own rulings to defend her position, forcing the justices to confront the very legal standards they had set. The First Amendment protects speech, even when that speech is critical of the judiciary, she argued. In Craig v. Harney, 1947, the court noted that criticism of judges is not only acceptable but vital to the health of a democracy. In that case, the court held that judicial officers must be resilient in the face of public criticism, as they are not immune from public scrutiny. Her points were well made, but what followed would truly change the trajectory of the proceedings. Leavitt, now fully in her element, pressed further. I acknowledge that as a government official, my position may present different considerations. However, in Garrison v. Louisiana, 1964, the court specifically held that critical speech by government officials, including public criticism of judicial decisions, is protected, unless it presents a clear and present danger to the administration of justice. My remarks posed no such danger. At this point, the tension in the room was palpable. The justices who had come into the hearing expecting a simple reprimand were now embroiled in a complex constitutional debate. Leavitt's arguments were not just legal, they were intellectually rigorous and well-grounded in the court's own past decisions. She was no longer just defending herself. She was challenging the very idea that a government official could be silenced for questioning a judicial ruling. Her legal references continued, and as she did so, the chamber grew quieter. Justice Sotomayor, who had been following the argument closely, raised a question. Miss Leavitt, she said, while your understanding of the law is impressive, don't you agree that there's a difference between criticizing a decision and questioning the integrity of the court? Your statements, though framed as legal analysis, seem to imply that the court has misinterpreted the law, which suggests a lack of good faith. Leavitt's eyes met Sotomayor's and she responded with poise. Justice Sotomayor, I understand your concern. However, in Wood v. Georgia, 1962, this court explicitly protected a sheriff's statements that accused judges of bias and political motivation. Far more pointed than anything I have said, the court recognized that public officials must be allowed to freely express themselves on matters of public importance. My statements, while critical of the court's decision, were not personal attacks. They were legal assessments. As Leavitt continued her defense, it became clear that she was not only prepared, but had anticipated the court's concerns. She deftly addressed each issue raised, citing case law and drawing on her own legal expertise. What began as a straightforward contempt proceeding had transformed into a sophisticated constitutional lecture. A lecture that forced the justices to reconsider their approach. By the time Leavitt finished, it was clear that this wasn't going to be the simple, one-sided proceeding that many had anticipated. The justices, while not abandoning their own views, were visibly grappling with the force of Leavitt's arguments. It was as if the balance of power had shifted. What had been meant to silence her was instead turning into a compelling constitutional debate, one that could change the way future administrations and the judiciary interacted. As she concluded, the courtroom was left in a rare silence. Leavitt had not just made a case for herself. She had laid the groundwork for a broader conversation about free speech, judicial power, and the future of political discourse in America. The tension in the room was almost unbearable as Leavitt made her closing arguments. The justices, who had entered the chamber expecting to witness a simple disciplinary proceeding, were now fully engaged in an intellectual and legal battle. What was supposed to be a straightforward case of contempt had become a complex debate about the very principles that govern the relationship between the executive and judicial branches of government. Justice Barrett, who had originally summoned Leavitt before the court, now found herself in an unusual position. Her carefully structured plan to reprimand a government official for criticizing the court was unraveling before her eyes. Leavitt's responses had been clear, well-reasoned, and grounded in the court's own precedents. Each time Barrett tried to steer the conversation back to the issue at hand, Leavitt deftly redirected it, presenting an unassailable case for why her comments should be protected under the First Amendment. It was becoming evident that this wasn't a simple contempt case. It was an urgent test of the limits of free speech and judicial power. Justice Barrett, though clearly attentive to Leavitt's argument, could no longer pretend that the situation was anything less than a constitutional showdown. As Leavitt continued to cite landmark cases, pointing out the court's own rulings that supported her right to criticize judicial decisions, the room seemed to shift. Barrett, once resolute in her position, now appeared to be weighing her words carefully. The court, which had historically maintained a very strict view of judicial authority, was being forced to confront the boundaries of that authority, especially when it came to the executive branch's right to speak out on matters of public concern. Leavitt paused, taking a breath before she delivered the most crucial part of her defense. She knew that if she could shift the conversation from a mere legal debate to a larger issue, one that touched on the fundamental nature of the American system of government, she could win this battle, not just for herself, but for future generations of Americans who would fight to protect their right to criticize the government. Justice Barrett, Leavitt began, her voice steady but firm. I believe this court is facing a critical question. It's not just about whether I have the right to speak my mind. It's about whether a democracy can thrive if its citizens, including those who work within the government, are silenced for questioning its institutions, including the judiciary. If we allow the court to move forward with contempt charges in this case, we risk sending a message that public criticism of the judiciary, no matter how justified or legally grounded, will not be tolerated, and that, I fear, will have chilling consequences for our democracy. Barrett's expression shifted, as if the weight of Leavitt's words was starting to sink in. The idea that this case could be a defining moment in the relationship between the executive and judicial branches, a moment that could affect how future generations viewed the boundaries of free speech, was a sobering thought for the court. Leavitt continued, unyielding in her conviction. We've seen throughout history that judicial authority cannot be exempt from criticism, especially when that criticism is based on a reasoned interpretation of the law. In fact, it is essential to the health of our democracy that all branches of government, including the judiciary, be subject to scrutiny. If the court were to proceed with contempt charges against me, it would send a dangerous message that even reasoned legal criticism is unacceptable when it comes from the government itself. And that is a fundamental threat to the very principles of free speech and open debate that our nation was built upon. Justice Barrett, who had earlier made it clear that she expected a simple retraction from Leavitt, now seemed to recognize that this wasn't going to be a typical proceeding. This wasn't a case of a government official simply stepping out of line. It was a case that challenged the very fabric of American democracy. Leavitt's arguments were powerful, and the justices, as much as they might have initially viewed this as a routine matter, could no longer ignore the larger constitutional issues at play. Chief Justice Roberts, who had remained mostly silent during the proceedings, leaned forward slightly, his expression one of deep contemplation. He exchanged a glance with Justice Kagan, who seemed visibly impressed with Leavitt's reasoning. Even Justice Thomas, who had been a more reserved participant throughout the day, seemed to be paying closer attention. The entire room was transfixed by Leavitt's defense. What had started as a disciplinary hearing had evolved into a pivotal moment in constitutional law. As Leavitt continued, she referenced yet another pivotal case, Garrison v. Louisiana, 1964, a Supreme Court decision that held critical speech by government officials to be protected unless it posed a direct and present danger to the administration of justice. Justice Barrett, Leavitt said, I would argue that my comments do not pose such a danger. They question the legal reasoning of the majority opinion, but they do not suggest that anyone should disobey the court's ruling. My statements do not incite violence or undermine the court's authority. They merely seek to address what I believe to be a flawed interpretation of precedent. At this point, Leavitt had skillfully shifted the conversation from a personal defense to a broader argument about the role of government officials in a democracy. She was no longer simply defending her comments. She was making a powerful case for the protection of political speech and the necessity of robust debate, even when that debate targets the judicial branch itself. Justice Barrett, who had initially been determined to reprimand Leavitt, now seemed to be reconsidering her approach. The tension was palpable. This wasn't just a confrontation between a press secretary and a Supreme Court justice. It was a fundamental moment of reflection for the court, forcing them to reckon with the balance between judicial authority and the essential right to criticize government institutions. The room was silent as Leavitt finished her argument, standing tall before the justices, her legal defense now complete. What had begun as a routine contempt proceeding had become something much more profound. Leavitt had not just made a case for herself, she had forced the court to grapple with the very principles that defined American democracy. Whether the justices would side with her or not, one thing was clear. Leavitt had proven herself a force to be reckoned with. Barrett, after a long pause, finally spoke. Miss Leavitt, I appreciate the thoroughness of your presentation, she said, her tone no longer as severe as it had been at the start of the proceedings. The court will need to consider the points you've raised. And with that, the fate of Leavitt, and potentially the future of judicial and executive relations, hung in the balance. The justices adjourned to deliberate, but Leavitt had already won a victory. She had demonstrated that the boundaries of free speech, especially when it comes to government officials, were far more expansive than many had previously thought. The court's eventual ruling would set a precedent that could either strengthen or limit those boundaries for years to come. The room remained thick with anticipation as Leavitt's words echoed in the chamber. What had begun as a seemingly straightforward contempt hearing had transformed into an unexpected constitutional debate, one that delved deeply into the heart of the First Amendment, the separation of powers, and the ability of government officials to criticize the judiciary without facing repercussions. The justices, who had originally expected a swift, simple conclusion to the case, now found themselves on the defensive. Leavitt's legal reasoning, sharp and precise, had challenged their assumptions and forced them to confront uncomfortable questions about the reach of their authority. Justice Barrett, who had come into this session expecting to assert her judicial power, now found herself engaged in an intellectual battle she hadn't anticipated. Throughout Leavitt's defense, Barrett maintained her composure, but it was clear that she was rethinking her initial stance. This wasn't just a reprimand anymore. It was a matter of constitutional interpretation, a matter that would require careful deliberation. Barrett leaned forward, her eyes narrowing slightly as she addressed Leavitt. "Miss Leavitt," she began, her voice calm but with an edge of intensity, "while your understanding of precedent is impressive, there remains the issue of your position. As White House Press Secretary, your words carry the implied authority of the executive branch. This is not just a matter of personal opinion. Your comments are not only criticisms, but have the potential to undermine the integrity of this institution." Leavitt, poised and unshaken, turned toward Barrett. "Justice Barrett, I understand the concern. However, I would argue that it is precisely because of the public position I hold that my words must be protected. As the press secretary, my role is to communicate the administration's stance on matters of public importance, and the court's ruling in Fairfield v. Department of Education is certainly a matter of public importance." She paused, making sure her point resonated. "The First Amendment is not just a protection for private citizens. It is a safeguard for public officials as well, especially when we speak out on matters that affect the public at large." Barrett listened, but her brow furrowed. "You suggest that because your comments are part of your official duties, they are somehow immune from legal consequences. But we are discussing criticism of the judiciary, not just a policy debate. As an officer of the executive branch, your comments have the potential to disrupt the functioning of the judicial system itself." There was a touch of frustration in Barrett's voice now. She had believed that the case was simple, that it would affirm the court's authority without hesitation. But Leavitt was unrelenting. "Justice Barrett, my criticism was not an attack on the judiciary itself. It was a legal argument about the court's interpretation of precedent in a specific case. As an official of the executive branch, it is my job to communicate the administration's perspective, including when we disagree with a ruling. If government officials are to be silenced in their criticism of judicial decisions, we risk creating an unaccountable judicial system, one that is beyond reproach and immune to the very checks and balances that form the foundation of our Constitution." Justice Alito, who had been quietly listening, now interjected with a pointed question. "Miss Leavitt, you've referenced several cases that protect the speech of private citizens and the press, but none of them address the specific context of government officials criticizing a decision made by the Supreme Court. Don't you think there is a distinction to be made between a citizen's right to criticize the court and a government official using their platform to do so?" Leavitt turned to Alito, confident but respectful. "Justice Alito, that's a valid concern. However, I would point out that throughout American history, public officials have criticized the judiciary without facing legal consequences. In Wood v. Georgia, 1962, for instance, the court protected the statements of an elected sheriff who publicly criticized judges, even accusing them of bias. The court held that public officials must be allowed to speak freely on matters of public concern, and that includes criticizing judicial decisions." There was a shift in the room as Leavitt's argument resonated with some of the justices. Leavitt had anticipated this line of questioning and had prepared her responses with remarkable foresight. Her ability to cite case law, combined with her clear, direct answers, put the justices on the back foot. This wasn't the interaction they had expected. What had started as a disciplinary proceeding against a press secretary had evolved into a deeply insightful legal debate, and it was clear that Leavitt was holding her ground. Justice Kagan, who'd been quietly observing, leaned forward and addressed Leavitt with a probing question. "Miss Leavitt, while your legal analysis is thorough, there is the issue of respect. When you criticize a decision from the Supreme Court, even legally, you risk undermining public confidence in the institution itself. At what point does criticism cross the line from legal argument to damaging the integrity of the court?" Leavitt paused for a moment, choosing her words carefully. "Justice Kagan, I do not seek to undermine the court's authority. My criticism was directed at the legal reasoning in the Fairfield decision, not at the court as an institution. There is a significant difference between challenging a legal interpretation and questioning the integrity of the court. In Landmark Communications v. Virginia, 1978, This court explicitly held that reputational injury alone does not justify restricting speech. Judges, like all public officials, must endure scrutiny. It is a necessary part of a functioning democracy. The room was silent as Leavitt finished speaking. It was clear that her defense had struck a chord. What had begun as a tense confrontation had evolved into something much more profound. Leavitt wasn't simply defending herself. She was challenging the court's assumptions about the boundaries of free speech, the role of government officials, and the relationship between the branches of government. Justice Thomas, who had rarely spoken throughout the proceedings, finally broke his silence. "Miss Leavitt," he said slowly, his voice deliberate, "while your analysis is impressive, there is one final concern. The court's role is to protect the integrity of judicial proceedings. If we allow criticism of the court to go unchecked, especially when it comes from those in positions of power, we risk eroding the public's trust in the very institutions that maintain the rule of law." Leavitt responded with equal deliberation. "Justice Thomas, I understand the concern about respect for the institution, but as you yourself have stated in previous decisions, free speech is one of the cornerstones of our democracy. If we start limiting that speech because it challenges the judiciary, we are setting a dangerous precedent. The law cannot and should not protect the court from criticism, especially when that criticism is based on legal reasoning and constitutional principles." As Leavitt concluded her argument, the tension in the room was palpable. The justices, who had entered the chamber with a clear expectation of a simple reprimand, were now faced with a formidable constitutional argument. Leavitt's defense had shifted the conversation from a personal matter of government criticism to a larger issue of constitutional principles that could reshape the balance of power between the branches of government. The court had a decision to make, and it was no longer just about Leavitt's fate. It was about the future of free speech and the limits of judicial power in a democracy. With a final glance at the justices, Leavitt stepped back, her argument complete. She had not only defended herself, but had forced the court to reconsider the boundaries of its own authority, setting the stage for what would undoubtedly be a landmark decision. The justices would deliberate, but Leavitt had already won a victory. She had shown that the law, in its most fundamental sense, belongs to everyone, not just those who wear the robes of the judiciary. As Leavitt stood poised before the justices, the gravity of the moment continued to build. The chamber, which had been filled with the sharp sounds of legal argument and impassioned debate, now seemed suspended in time. The weight of the question at hand, whether a government official, in this case the White House press secretary, could be charged with contempt for publicly criticizing a Supreme Court decision, hung heavily over the room. What had started as a reprimand, an attempt to punish a government official for speaking out, had transformed into a defining moment that questioned the very balance of powers within the United States government. Leavitt had already delivered a powerful legal defense, but it wasn't just her arguments that had caught the justices' attention. It was the poise with which she carried herself, the way she had taken control of the courtroom and turned it into an arena for a deeper constitutional discussion. Each time the justices attempted to narrow the scope of her defense, she countered with precision, leveraging their own precedents to make her case. Despite her calm demeanor, Leavitt knew that the stakes had become far greater than she initially imagined. The court, which had been expected to issue a swift judgment, was now deeply immersed in a conversation about the limits of judicial power and the scope of free speech. The justices, known for their careful deliberation, were forced to confront questions they hadn't anticipated when they summoned her to answer for her remarks. Leavitt had raised a challenge to the very framework of the court's authority, forcing them to reckon with their relationship to the other branches of government, as well as the public's right to criticize judicial decisions. Justice Kagan, whose voice had been one of the more pointed throughout the proceedings, now asked a question that seemed to cut to the heart of Leavitt's argument. "Miss Leavitt," she began, her tone measured, "while I appreciate the legal references you've provided, there is a fundamental concern about the respect due to this institution. You have made it clear that your words were intended to express a disagreement with the court's ruling in Fairfield v. Department of Education. However, some might argue that by doing so, you are not just criticizing a legal decision, you are questioning the very legitimacy of the court's role in our system of governance. How do you reconcile your remarks with the need for maintaining respect for the judiciary as an institution? Leavitt paused, her mind racing, but her voice remained steady and confident as she responded. Justice Kagan, I appreciate your question, but I would respectfully submit that my comments were not directed at the integrity of this court, nor do they undermine its authority. My statements were aimed at the legal reasoning in a particular case. I have not questioned the legitimacy of the court's role or the court's authority to issue rulings. What I have criticized is the way the court interpreted the legal precedent in Fairfield. That is, after all, what the court's decisions are based on, the interpretation of the law. And as a government official, I believe it is not only my right, but my duty to express the administration's position on such matters, particularly when I believe that position is rooted in legal principles that reflect the Constitution. Leavitt's answer was poised, but what was more striking was the strength of her argument. The court, as much as it was a powerful and respected institution, was not above scrutiny, especially when it came to its interpretation of the law. Judicial authority, Leavitt reminded the court, was not immune from critique, particularly when it could have far-reaching consequences for the administration of justice. By citing Craig v. Harney, 1958, and New York Times v. Sullivan, 1964, Leavitt had already established the legal framework for her defense, but it was in moments like these that the court could feel the impact of her reasoning on a much deeper level. Justice Thomas, who had remained mostly silent until now, seemed to sense the gravity of the moment. He had long been an advocate for a judiciary that remained insulated from public influence, viewing such insulation as essential to maintaining impartiality and integrity. He leaned forward and asked, Miss Leavitt, you argue that public officials should be allowed to express their opinions about judicial rulings. But where do we draw the line? If every government official feels free to criticize the court, what happens to the respect and authority of the judiciary? Can there not be a point where such criticism undermines the public's faith in the rule of law? Leavitt turned toward Justice Thomas, the weight of the question not lost on her. She had anticipated this very argument, and her response was ready. Justice Thomas, I recognize the concern you raise, and I do not take it lightly. But I would submit that it is precisely because of our respect for the rule of law that we must protect robust debate about judicial decisions. The court itself has noted in Texas v. Johnson, 1989, that the First Amendment protects speech, even when it is sharp, critical, and uncomfortable. If we limit the ability of government officials to voice their concerns about the judiciary, we are opening the door to a situation where public debate is stifled, and the court becomes immune from accountability. And I do not believe that a democracy can thrive in such an environment. Her words echoed through the chamber, and for the first time, several justices seemed to reflect on the broader implications of what Leavitt was saying. She wasn't just defending her right to speak, she was articulating a broader vision of democratic governance, one in which criticism, no matter how uncomfortable, was not only protected, but essential to the health of the system. For all the legal arguments Leavitt had made, it was this deeper, more fundamental belief in the power of free speech that had begun to resonate most powerfully with the court. Justice Alito, who had raised concerns earlier about the potential consequences of government officials criticizing judicial decisions, now looked up from his notes and asked, Miss Leavitt, do you believe there are any limits to the kind of speech government officials can engage in when criticizing the court? If so, what are they? Leavitt, now fully immersed in the conversation, answered with confidence, Justice Alito, I do acknowledge that there must be limits to free speech. There always are. However, those limits should be based on the potential harm caused, not simply on the substance of the criticism. For example, direct incitement to violence or attempts to undermine the court's orders would clearly cross the line. But criticism of legal reasoning, even when it is sharp or pointed, should not be deemed illegal. As long as the speech does not threaten the administration of justice, it falls squarely within the protections of the First Amendment. The room seemed to settle into a tense quiet as Leavitt finished. Her arguments had left an indelible impression on the justices. The questions had evolved from concerns about personal criticism to a broader examination of constitutional principles, the role of public officials, and the limits of judicial authority. It was clear that Leavitt's defense had raised far-reaching issues that went beyond her individual case and reached to the heart of the balance between government branches, the role of the judiciary, and the rights of citizens, including those who served within the government, to speak out on matters of public importance. The chamber was left in an unusual silence as the justices took in Leavitt's final words. This was no longer just a legal proceeding. It was an ideological moment that would shape the interpretation of free speech and the nature of judicial power for years to come. The justices would now retreat to deliberate, but Leavitt had already achieved something extraordinary. She had not just defended her right to speak, she had forced the court to confront the broader implications of its decisions regarding the limits of speech and the role of government officials in shaping public discourse. As the justices filed out, the tension remained palpable. Leavitt had made her case, and the court was now tasked with a monumental decision. The outcome would resonate well beyond this case. It would send a message to future generations about the importance of free speech, the role of government officials in holding the judiciary accountable, and the power of the First Amendment to protect even the sharpest of criticisms. As Leavitt finished her argument, the room remained still, the weight of her words lingering in the air. She had made her case not just for herself, but for the fundamental right of government officials to speak freely and criticize judicial decisions when they felt it was warranted. It wasn't just a defense of her remarks, it was a defense of democratic principles, ensuring that even the most powerful institutions could be held accountable. The justices, visibly deep in thought, exchanged glances as if reconsidering the traditional boundaries of judicial authority. Leavitt had forced them to confront the delicate balance between respecting the court's integrity and protecting the right to free speech. The court would deliberate, but the implications were clear. Whether or not they found in Leavitt's favor, her argument had shifted the narrative, ensuring that the lines between judicial power and free speech would be reevaluated for years to come. As the proceedings came to a close, Leavitt stood tall, knowing she had made history, not by backing down, but by challenging the very foundations of legal authority with grace, precision, and courage. In the end, Leavitt's battle was more than a personal victory. It was a monumental moment for free speech in America. What started as a reprimand from the court became a testament to the strength of the Constitution and the power of holding institutions accountable. Bookmark. If you found this story as riveting as we did, make sure to like, subscribe, and share your thoughts in the comments below. How do you think the court should handle government officials criticizing judicial decisions? Let us know, and don't forget to hit the notification bell for more insightful legal breakdowns. Thanks for watching. See you in the next video.